It is my great pleasure to welcome Judge Xue Hanqin here to Washington University School of Law. She was appointed to the International Court of Justice in June of 2010, and prior to that had a very, very long and distinguished career working in the Chinese Foreign Ministry, handling international negotiations on behalf of her country, as a law professor, and of course as a distinguished scholar in international law. Judge, thank you so much for joining us at Washington University.
Thank you very much, and thank you for your kind words.
Oh, it's our pleasure. Before you became a judge at the International Court of Justice, you had a very distinguished career with the Chinese Ministry of Foreign Affairs. Can you tell us a little bit about how you got into that career and some of the aspects of it that you most enjoyed?
Well, to begin with, I have to make clear that my career is very simple. When you say it's distinguished, I have to say distinguished in the sense I worked in the area that developed very fast with the change in China. For that, I take pride. I got into foreign service at a time when China just started its economic reforms and adopted open policy. Right away, the country felt great need of legal expertise in international law. And because of the Cultural Revolution, our law schools just started, reopened, and we need a legal person. And I found great interest in studying international law.
And when you went to Columbia University in 1983, is that right? 82. What was the, what did you like, or what was different for you? How did you find studying in the United States?
It's eye-opening, I have to say. At that time, Chinese law schools just started, and we need legal experts in international law. I was very fortunate to work with a group of very distinguished senior jurists, legal counsels in the Foreign Ministry, the legal department of the Foreign Ministry, from whom I learned a lot. That paved my way for my subsequent study at Columbia. At Columbia, I was again very lucky to study with such distinguished professors as Professor Xue Hanqin, Professor Xue Hanqin, and Professor William Rees, that's in private international law, and Professor Richard Gardner. I was deeply impressed by the American legal system and how it functioned in the society. That's the beginning of my knowledge, my learning of American legal system. And I think that it has great impact in my career.
And many years later, you told us a little bit in the meetings earlier, you had to take on a very difficult negotiation for the Foreign Ministry when the United States bombed the Chinese embassy during the Kosovo intervention. And do you think your background, understanding of U.S. negotiation or U.S. law helped you? Tell us a little bit about that, because I know that was quite an interesting negotiation, if you're able to speak about it.
It's only one of the cases I dealt with.
True.
Actually, since the normalization of the relations between our two countries, there have been a lot of cases, legal cases between our two countries. During our previous conversation, you mentioned about the U.S. bombing of the Chinese embassy in Belgrade. That's only one of the cases. Actually, there are many others. I think the two sides, the two countries, had the willingness, political will, to solve those problems through direct negotiations. And the legal experts only add to the effort. And so this is something I found legal education between our two countries so helpful and so useful.
And you've led many very interesting negotiations on climate change. You've worked on issues of nuclear proliferation, I think, for the IAEA, the Women's Convention. Which of those treaty negotiations did you find maybe most interesting, or what issues arose in your work there?
Normally we, well, it's very difficult to tell which one is most interesting. I would say all of them are very interesting. Generally, we refer to those negotiations as bilateral negotiations for bilateral treaties or bilateral issues, and multilateral negotiations that within the framework of the United Nations and the auspices of the organization. I have to say two kinds of negotiations are both very enjoyable. Enjoyable and requires your legal expertise as well as political experience. And of course, it's never one person's act because you are the representative of the country. You work under the instruction of the government. At the same time, you do have the initiative to add your individual contribution. But on the whole, it's a collective teamwork of the delegation. So it's very difficult to say which one is most interesting for a person, for one participant. I have to say, personally, I gain a lot through the process and get a much better appreciation of the discipline itself in the context of foreign service.
And do you have any advice you could give our students as to what they should learn to prepare themselves if they would like to follow in your footsteps and work for a foreign ministry in the United States or abroad?
I think, well, that's a good question. I think for law students in general, this is the important stage for their career. I found in the American legal education, your career starts not at the moment when you graduate, not at the moment of commencement. It's really the moment that you enter the law school. So every step of the way of your career, you have to start from the first one, that's the legal education. You study at the law school. So my advice is to lay a solid foundation of your legal profession. Study hard at law school. For Chinese law students here, I have another dimension to add. That is, apart from your legal education, solid foundation, try to study as much as possible. Try to understand as much as possible about American legal education, American legal system, how it works, how it functions in its social, political, and economic context. Because once you understand that, it will be very helpful for the students later to practice law in the Chinese context, which I didn't mean that they simply apply American law. How they use the legal knowledge to promote social development. That's the message I want to give to the law students here.
You also, as part of this very distinguished career, you were on the International Law Commission for many years.
Yeah.
And you told us earlier you had been the first woman named as chair, which I didn't know. Can you tell us a little bit about your time on the commission? What maybe some of the issues that were interesting? What was it like to be the first woman chair? If that was special or not?
Actually, I was elected to the Law Commission, International Commission in 2002, together with the Portuguese member, Paula Extremir. We were the first two women members to the Law Commission. Well, I think both of us, through our hard work, proved to the rest, to the people that women can distinguish themselves in the field by their competence, not because of their gender. In 2010, that's the 9th year of my membership in the Law Commission, I served in the first half of the session as the first woman chair in the Law Commission. Unfortunate, I have to say, later I was elected to the court, so I have to left the Law Commission without fulfilling my duty as the chairman. The feeling I got from my experience in the Law Commission was times have changed. And there are many very accomplished women lawyers there. They can do as their colleagues, male colleagues, to make their contribution to the development of international law. I never felt anything particularly different from male colleagues. And individually, we should not always think about the gender. Of course, policy-wise, this is an important element. But for ourselves, we strive for excellence, strive for competence. On that basis, we can make our contribution.
And obviously your government found you to be extraordinarily well qualified, because then China nominated you to the International Court of Justice. You were appointed for the first part of the term, is that right? And then you ran for election subsequently, as all judges have to. Can you talk to us a little bit about what that was like, having to campaign, if you did campaign, for election to the ICJ?
I just feel I'm lucky enough to be nominated by our national group and some other national groups of other countries to the position, and to stand the election by the General Assembly and the Security Council to the membership of the International Court of Justice. I know out there are other outstanding international lawyers in China and women lawyers in China. I'm just the lucky one to be nominated. This is something I felt that I have the heavy responsibility to fulfill the task. And when the General Assembly and the Security Council elect members to the court, the member states really entrust that these members will fulfill their duties according to the terms of the statute of the court.
Do you think China will ever bring a case to the court, or do you think China might accept the compulsory jurisdiction of the court at some point?
At this stage, I don't see in the conceivable future China would. So far, China has always made reservation to any treaty clause relating to the jurisdiction of ICJ. And China has not made any declaration on the acceptance of compulsory jurisdiction of the court. There are a lot of reasons for that. Advanced commitment to the jurisdiction of the court is not an easy decision for any country. The same is true with China. But I have to say, China attaches importance to the work of the court, because the role the court plays in the peaceful settlement of international dispute is highly appreciated by China. For the disputes China has with other countries often involve very complicated political, historical factors. And that's why China so far adhere to the means of direct negotiations, also with the view for lasting, stable, peaceful relations with other countries. It will take time. And since China adopted economic reform and open policy, it has adjusted its position towards a third-party settlement in the commercial and economic fields. For ICJ, not yet there. But in 2009, for the first time, China submitted its written observation statement on the issue of Kosovo and appear for the first time before the court in the oral proceedings. So this is a first attempt, and is a good one, I would say.
This is a very exciting time for the court. It has more cases than it's ever had before, and the kinds of disputes going to the court are very different. Is there any particular aspect of your work there that you found particularly fascinating or surprising or unexpected, perhaps?
Not really.
No.
Not really. But I feel very encouraged that there are so many cases now before the court. And through the practical work, I could tell states parties before the court do place their trust in the court for settlement of disputes. And currently there are 13 cases pending, and the subject matters before the court really quite diverse, and some of them really touch on the cutting-edge issues of contemporary international law. So that's encouraging. Surprise? No surprise. And it's a good thing. I don't feel surprised.
Lots of hard work and lots of interesting cases.
Exactly,
it sounds like.
Exactly. Really demanding now.
Yeah.
And the court has very limited resources. We hope that member states of UN could give more understanding and support in terms of allocation of resources.
And finally, you've been a professor as well at Wuhan University, and that's where Bill Jones was teaching as well. I know that as a professor, just hearing you talk over the last day or so, your students must have been thrilled by your courses. What did you teach in China? And do you think you'll go back to teaching, or would you like to teach part-time while you're at the court?
It's very kind of you to mention that. When I say in my resume, you may notice I gave lectures at several law schools, but not in the sense as a full-time faculty member. We have a different system in China because of the special role of the legal department in the field of public international law. So oftentimes our officers have been asked to give lectures at law schools on contemporary issues of international law. But for me, myself, I have never lost interest in teaching. I always like to have contact with the law students, the young people, and exchange views with them on the issues of international law. That's why I gave lectures at several universities, and then they extended a professorship to me, hoping that I could give more lectures there. But oftentimes, because of the time constraint, I failed in my responsibility. But now in court, I will try my best to do as much as possible during my home visit, vacation, and here and there give lectures elsewhere.
Yeah.
So this is something I think mainly of my personal interest.
Well, Judge, thank you so much for taking the time to be part of our Global Law Talks. We're very much looking forward to your lecture here at Washington University today.
Thank you very much.
And we're both honored and delighted to have you at the School of Law. Thank you.
Pleasure is mine. Thank you.
Thank you.